Welcome to the New Sentinel, where deep dives meet clear, practical intelligence analysis.
Today, we examine birthright citizenship, historic exceptions, new orders, and expected legal challenges.
We will keep this focused, detailed, and useful for listeners tracking law and policy.
And yes, if you value this work, view, subscribe, comment, and stay engaged.
If you are an entrepreneur, we can help advertise your product or service.
Now to the issue. Birthright citizenship rests on the 14th Amendment's Citizenship Clause.
That clause covers persons born in the United States and subject to its jurisdiction.
The fight is over, those last words, subject to the jurisdiction thereof.
Historically, the classic exceptions are narrow: foreign diplomats and enemy occupying forces.
Children of foreign diplomats are not fully subject to ordinary United States jurisdiction.
They are physically present, but diplomatic immunity changes the jurisdictional relationship.
Enemy occupying forces are the other core exception, because allegiance is openly hostile.
In that case, birth on soil does not reflect normal sovereign protection and obligation.
Those exceptions were not written as broad immigration control tools.
They were rooted in allegiance, immunity, and wartime sovereignty.
That distinction is central to every likely lawsuit over the new orders.
I'm tapping the table on this point. Narrow exceptions do not automatically create broad exclusions.
Exactly. The administration appears to be arguing by analogy from those exceptions.
Its likely theory is that some parents lack sufficient political allegiance or lawful attachment.
That interpretation tries to move from diplomatic immunity toward immigration status.
Critics will say that move conflicts with the traditional understanding of territorial citizenship.
Supporters will say jurisdiction means more than geography and ordinary criminal authority.
The Supreme Court precedent, most often discussed here, is United States v. Wong Kim Ark.
That case strongly supports citizenship for most children born on United States soil.
It recognized the diplomat and occupying force exceptions, but did not expand them broadly.
The administration's challenge is turning exceptions into a larger governing rule.
That is a legally high-risk maneuver.
Let's frame this as an intelligence report, starting with the core assessment.
Core assessment. The orders likely seek a test case for constitutional reinterpretation.
They also likely aim to deter birth tourism through documentation and enforcement pressure.
But the birthright order faces stronger constitutional obstacles than the birth tourism order.
Because denying citizenship directly collides with entrenched constitutional doctrine.
Birth tourism rules, by contrast, often operate through visas, entry screening, and fraud enforcement.
Those areas give the executive branch more room, though not unlimited room.
Now, the historical exceptions: diplomats, occupying forces, and sometimes tribal status history.
The tribal history is distinct and legally different from the modern immigration debate.
It involved separate sovereign relations and was later changed by federal law.
Using that history against children of migrants would be controversial and contested.
Diplomatic children are different because the parents are exempt from many local legal processes.
Occupying force children are different because the occupying army rejects normal sovereign authority.
Neither category naturally matches ordinary undocumented parents living under United States law.
Those parents can be arrested, sued, taxed, removed, and prosecuted.
That fact supports the argument that they are subject to jurisdiction.
The administration may respond that full jurisdiction requires undivided political allegiance.
But that theory is exactly where the litigation will become intense.
Let's move to most analysis: mission, objectives, strategy, and tactics.
Mission. redefine birthright citizenship limits, and reduce citizenship incentives tied to birth tourism.
It is also a mission to shift constitutional debate toward allegiance and consent.
Objectives: deny automatic citizenship in selected cases, change agency guidance, and force judicial review.
Another objective is signaling, showing voters a tougher posture on immigration and documentation.
A further objective is bureaucratic alignment across passports, vital records, immigration, and benefits.
Strategy: use executive orders to create immediate policy change and controlled litigation pathways.
The strategy likely depends on rapid appeals and eventual Supreme Court consideration.
It also uses uncertainty as leverage, even before final judicial resolution.
Tactics include revised birth documentation, passport holds, citizenship evidence demands, and agency instructions.
For birth tourism, tactics may include stricter visa questioning and fraud-focused investigations.
There may also be interagency data sharing around travel purpose, residence, and payment patterns.
Those tactics will be challenged if they produce arbitrary or discriminatory outcomes.
Now the SWOT analysis, starting with strengths.
Strength 1. The orders use real historical exceptions, not invented categories.
Strength 2. Immigration and visa control are areas where executive power is traditionally substantial.
Strength 3. Public concern over birth tourism gives the policy a political narrative.
Strength 4. Creating a live controversy can move the constitutional question through courts.
Weakness 1. The historic exceptions are narrow and may not support the broader interpretation.
Weakness 2. Wong Kim Ark remains a major obstacle to restricting citizenship by parent status.
Weakness 3. Implementation could create chaos for hospitals, states, parents, and federal agencies.
Weakness 4. Inconsistent agency standards could strengthen due process and equal protection claims.
Opportunities include clarifying the boundary between birthright citizenship and immigration enforcement.
Another opportunity is targeting fraudulent birth tourism schemes without rewriting constitutional citizenship.
The administration could win more ground on fraud, visas, and misrepresentation than citizenship denial.
Threats include nationwide injunctions, fast adverse rulings, and administrative paralysis.
Another threat is that courts may reaffirm broad birthright citizenship even more strongly.
A political threat is backlash from families, hospitals, business groups, and state governments.
A diplomatic threat is friction with countries whose nationals are affected.
Now, legal challenges are already foreseeable in several tracks.
Track 1. Constitutional challenges under the 14th Amendment's Citizenship Clause.
Plaintiffs will argue the executive cannot alter constitutional citizenship by order.
Track 2. Statutory claims involving passports, immigration benefits, and agency authority.
Plaintiffs may argue agencies are acting beyond powers Congress actually granted.
Track 3. Administrative Procedure Act claims, especially if guidance is abrupt or unexplained.
Those challenges may allege arbitrary, capricious, or procedurally defective policymaking.
Track 4. Due process claims from affected children and parents.
If documents are withheld without clear procedures, courts may scrutinize the process closely.
Track 5. Equal protection arguments if enforcement disproportionately targets certain nationalities.
The government will likely deny discriminatory intent and emphasize status-based classification.
But evidence, statements, and enforcement patterns could matter.
Standing will be important, but many plaintiffs could plausibly show concrete harm.
Parents, children, states, hospitals, and advocacy organizations may all attempt claims.
States may claim administrative costs, benefits, complications, and vital record burdens.
Individuals may claim denial of passports, social security numbers, or legal recognition.
The government may argue some injuries are speculative until final agency action occurs.
Courts often move quickly when citizenship status and family rights are at stake.
Temporary restraining orders and preliminary injunctions are therefore highly likely.
The key injunction question will be likelihood of success on the merits.
For the birthright order, plaintiffs likely have a strong initial argument.
For birth tourism measures, the outcome is more mixed.
Visa screening gets deference, especially outside the country.
But domestic citizenship denial receives far less deference.
Consular non-reviewability may shield some visa decisions from routine judicial review.
Still, if a visa rule is tied to unconstitutional citizenship logic, challenges may intensify.
The administration's strongest lane is fraud prevention, not citizenship redefinition.
Its weakest lane is denying citizenship to children born under ordinary territorial jurisdiction.
Let's clarify the post-Barbara framing mentioned in debate around these orders.
The term is not universally clear, so any assessment must be cautious.
If it refers to a post-decision interpretive posture, the administration seems to read exceptions expansively.
That means treating limited historical exclusions as evidence of a broader allegiance principle.
Opponents will call that selective history rather than faithful constitutional interpretation.
Supporters will call it restoring the original meaning of jurisdiction.
The courts will likely ask whether status-based exclusions were actually recognized historically.
They will also ask whether executive power can create them without Congress or amendment.
That second question may be decisive.
Even judges sympathetic to stricter immigration enforcement may resist executive constitutional revision.
Now, expected timeline.
First, immediate lawsuits in multiple federal districts.
Second, emergency requests for temporary restraining orders.
Third, conflicting district rulings are possible, though early injunctions are likely.
Fourth, appeals to regional circuit courts.
Fifth, emergency applications may reach the Supreme Court.
A merits ruling could take longer, depending on implementation and case posture.
The administration may prefer a clean record showing specific denied documents.
Plaintiffs may prefer broad challenges before families face irreversible harm.
Operationally, hospitals are not immigration courts.
That practical reality matters.
Birth certificates are generally state records, not final federal citizenship adjudications.
Federal agencies then rely on documents for passports, benefits, and identity.
If agencies impose new proof demands, bottlenecks could multiply quickly.
That supports arguments about irreparable harm and administrative confusion.
It also creates political pressure on state officials and local health systems.
For families, uncertainty itself can be severe.
A newborn's passport, insurance, travel, and identity records can all be affected.
For the government, the enforcement challenge is screening without overreach.
Birth tourism investigations may target organized schemes, misrepresentation, and payment networks.
Courts are more likely to accept that than blanket citizenship restrictions.
So the most viable policy path is narrow anti-fraud enforcement.
The highest risk path is denying citizenship based on parental immigration status alone.
Let's state the bottom line clearly.
Historical exceptions exist, but they are limited and status-specific.
Diplomats and occupying forces are not ordinary migrants, visitors, or undocumented residents.
The administration's interpretation depends on broadening jurisdiction into an allegiance test.
That theory faces serious constitutional, precedential, and operational obstacles.
The birthright order is likely to face immediate and strong legal resistance.
The birth tourism order may survive in part if framed around fraud and visa authority.
But if it functions as indirect citizenship denial, it becomes more vulnerable.
For intelligence purposes, risk is high, litigation is certain, and outcomes are uneven.
Policy durability will depend on judicial acceptance of the administration's jurisdiction theory.
At present, that acceptance should be treated as uncertain and contested.
The most probable near-term result is injunction-driven delay and accelerated appellate review.
The most consequential long-term result would be Supreme Court clarification.
And that clarification could either narrow birthright citizenship or reaffirm it broadly.
For now, the legal battlefield is the meaning of jurisdiction.
The policy battlefield is documentation, visas, and agency implementation.
The political battlefield is whether voters see this as enforcement or constitutional overreach.
That is the strategic picture.
You have been listening to the New Sentinel.
Stay informed, stay critical, and keep watching the legal signals behind the headlines.